Section 116 is about the bequest to take effect on failure of prior bequest. Means where by the reason of any of the rules contained in section 113 and 114. Section 113 is about the bequest which is made to the unborn person, and 114 is about the rule against perpetuity. Perpetuity means never ending. So any bequest in favor of a person or a class of a persons is void in regard to such person or the whole of such a class, and the bequest contained in the same will and intended to the effect after or upon the failure of a such prior bequest is also void, and that bequest which is contained in the same will and intended to the effect after or upon the failure of a such prior bequest is also considered as a void. This is according to section 116. And section 117 is about the effect of the direction for accumulation. Means where the terms of a will direct that the income arising from any profit shall be accumulated either wholly or in a part during any period of 18 years from the death of the testator. Means here the will directs that the income arising from the property shall be accumulated either wholly or in a part during the any period of 18 years from the death of the testator. Such direction shall save as hereinafter provided be void to the extent to which the period during which the accumulation is directed exceeds a foresaid period, and at the end of the such period of the 18 years the property and the income thereof shall be disposed of as if the period during which the accumulation has been directed to be made had lapsed. Means according to the given specified period only the wealth can be accumulated. Beyond that the wealth cannot be accumulated. This section 117 shall not affect any direction of the accumulation for the purpose of the payment of the debts of the testator or any other person taking any interest under the will. Means in these cases it will not affect any direction of the accumulation for the purpose. First is the payment of the debts of testator or any other person taking any interest under the will, or the provisions of the portion for the children or remoter issue of the testator or any other person taking any interest under the will. First is about the debts. Second is for the portion of the children or the remoter issue of a testator. Third is the preservation or the maintenance of any property bequeathed, or such direction may be made accordingly. This section has been amended in order to lay down definitely on the lines of the English law the periods and the objects for which the condition as to the accumulation should be held valid. Means for what period the accumulation of the wealth can be considered as valid. The amended section permits the accumulation during the following periods only: the life of testator or the period of 18 years thereafter. Means the accumulation of the